Good afternoon. This is Russell Berger. Thank you for joining us this afternoon. We're going to wait just a minute to make sure everyone has a chance to get on the line. Good afternoon again, and welcome to Wage and Hour Law Part 2, How to Properly Calculate Employee Time. Today we will cover how to correctly track employee hours worked, which is critical to ensuring minimum wage and overtime compliance. Before we get started, feel free to submit questions as we go. I'll try to answer as many as possible. While many of you may have joined last week's webinar on employee misclassification issues, for those of you that were not on that webinar, my name is Russell Berger, and I'm the chair of the Labor and Employment Group here at Offit Kurman. I work with business owners to address the 3 P's of employment law: people, policies, and problems. And in that capacity, I spend most of my time addressing wage and hour problems in both the litigation and compliance context. Now, this slide should look familiar to those of you that were on last week's webinar. And by the way, if you missed last week's webinar, it can be downloaded from the Offit Kurman website, and it's a good primer on what we're talking about here today. But in any event, to state it simply, federal and state laws require certain employees who are classified as non-exempt to be paid minimum wage and overtime. In addressing wage and hour issues for clients, 3 main categories of problems arise. 1, misclassification, which again is what we discussed last week, and this really covers disputes as to whether an individual is actually an employee or an independent contractor, as well as whether someone who is clearly an employee is exempt or non-exempt from the requirements of the overtime law. The second main category is timekeeping, which is what we'll be discussing today. And this covers where there are disputes over the amount of time actually worked by the employee. And the third category, which is something that we'll cover next week, is miscalculation of the rate at which overtime hours should be paid. So again, is the individual eligible? How many hours has that individual worked? And what is that individual owed for those hours worked? Today we'll be focusing on the middle category. Now, there are 2 main reasons why time tracking is so important to employers. First, it's required by the law. So the Department of Labor has the ability to enforce this record-keeping requirement, and if it conducts an audit, it could identify a deficiency in your practices if you're not properly tracking time. This alone does not pose much risk, given that there aren't really significant or steep financial penalties for failing to comply with the timekeeping requirement. However, secondly, without good time records, it's impossible to prove wage and hour compliance. For example, minimum wage compliance is measured by dividing total pay for the week by the total number of hours worked. So in order to establish that the individual employee was paid at least the minimum wage for all hours worked, you need to know how many hours were actually worked. Similarly, non-exempt employees are owed premium pay for overtime. And you need to, in order to properly comply with that requirement, you need to know the hours worked and if and how much of the hours worked qualify as overtime. So from a very simple starting point, non-exempt employees should not be permitted to work without recording their time. A critical aspect of tracking time is understanding the unit of measurement. That is, what is work time? Now, the Fair Labor Standards Act, which is the applicable federal law, uses the term to suffer or permit to work. And what that means is that work time need not be requested by the employee, just permitted by the employer. And even that is a pretty loose definition. For example, if an employee is supposed to leave the office at 5 o'clock but stays late without authorization, that is work time and needs to be paid. Now, as an employer, you have a right to dictate what hours can and cannot be worked, so you have an ability to discipline an employee for failing to follow company policy with respect to what hours can be worked. However, you cannot dock their pay. If the work is done, then the employee needs to get paid for it. And I will give you a good example of that. That happens here in my office. We have a requirement that support staff leaves at a certain time each day because we manage their time and we manage support staff time so that we do not have to pay overtime for it, except in rare circumstances. And what has happened to me is the administrative assistant has said to me, no, that's fine. I'll just stay late and get that out today. It'll only be 15 minutes. I just won't report that time. And of course, saying it to me is probably the absolute wrong person to say that to in my entire firm, because I then have to tell the employee, you can't do that. You've either got to get permission and you've got to go through the proper channels and you have to report the time, or you have to leave at 5 o'clock. You cannot stay late and work off the clock, because I know that if that happens, that creates a real risk for my firm, because now someone's working hours that aren't being tracked and aren't being recorded and could come back and claim that they were not paid an overtime premium for those overtime hours worked. Another point about what is work time is that the workday starts and ends with the principal activity. So once the workday gets started, with limited exception, the clock is running until the end of the day. Now, there's a whole litany of cases that address things like donning and doffing uniforms and safety gear, and really, what this area of the analysis turns on is whether the conduct engaged in is the principal activity or whether it is a preliminary activity. So there are cases out there that say, putting on a uniform or putting on some security gear or safety gear is preliminary to the principal activity of the day, whatever that might be for that individual worker. And there are cases that go the other way on that same question. And it's really going to be a fact-specific analysis. And it's the same type of analysis at the end of the day. Is this a continuation of the principal activity for which this employee has been engaged to work, or is it something separate and post-preliminary? Now that we have a general idea as to what we are tracking, we should discuss best practices for tracking time. My personal preference is for automated or digital systems that reduce the risk of misuse. And by that I mean things like passcodes, thumbprints, and phone apps. And the reason I like them is because, on the one hand, they reduce the risk of employees punching time cards for one another, while also providing a digital record of the hours worked, which is a lot harder to challenge. So, for example, in contrast to these electronic methods of tracking time that I just mentioned, there are more traditional methods of tracking time, whether it be a time card or a handwritten timesheet that gets submitted to HR at the end of the week. And the time card is probably somewhere in the middle in terms of the risk, since other employees can punch someone else's time card, people can punch it later. For example, employees could leave a little bit early and have one person stay to punch everyone out at the same time. So there's a little bit more room or manipulation of a time card than there is a digital timekeeping system where each individual employee has to punch out using his or her code or using his or her own phone. That's obviously a little bit less risky in that respect. And in addition, depending on what type of work your employees are doing, some of these systems provide for GPS tracking. So if someone's out on the road or travels a fair amount, it can also geocode the location of when these time punches are made. So there's a level of verification that the person was still working or working up until the time that they punched out. Then on the opposite end of the spectrum is the either computer or handwritten timesheet where the employee just punches in, writes in their hours started, their hours ended, and whatever meal breaks they may have. And obviously that's totally dependent on what the employee puts on the timesheet. And there may be some places where that still makes sense to use, but I just don't see that as being a great or useful tool in this day and age when we have the ability to use digital systems that can provide better detail and with less risk. However, there's a little bit of a downside with digital records, and frankly, this exists with all sorts of records, and it's that there are concerns about rounding practices. And while rounding is permitted under the FLSA, it cannot be used to the disadvantage of the employee. And by that, I mean you can't always round in such a way that it favors the employer. The idea is that if rounding is used because it's a more convenient way to track hours worked, then that's okay as long as it's neutral in its application and it doesn't just benefit the employer. So, for example, if you had someone who was supposed to work 9 to 5 and you had a system that rounded to the nearest quarter hour and employees showed up 5 minutes early and maybe worked 5 minutes late on a habitual basis, that system wouldn't necessarily be fair. And even rounding to a nearest quarter hour isn't that bad of a system. What you sometimes see is a rounding up or rounding down in such a way that it just consistently benefits the employer, and that's something that needs to be avoided. Along those lines, it's really critical that if you do implement some sort of rounding, which, again, given the prevalence and the development of digital systems, you might be able to avoid that entirely. But if you do use the rounding system, it's critical that you understand how your rounding system works. Now, I've had cases where employers thought the rounding system was doing one thing, for example, rounding to the nearest quarter hour, but it wasn't. Instead, it was rounding to the shift start time or the shift stop time, because that's what the default was in the software, and they didn't understand it or they misunderstood it. And as a result, that creates a level of exposure because there's time for everyone that's using this system that's going uncalculated and therefore not being compensated. Whatever system you use, I think it's also critical that supervisors understand the system. And while they don't have to be an expert in it, I think it's important that they have a knowledge of the basic rules, or at the very least, they know when to call human resources. Because oftentimes employees that are using some sort of timekeeping system will ask their manager, "Hey, I have this problem. What do I do?" Or "How do I use this system? What am I supposed to do?" And the manager or the supervisor needs to be able to answer that question or get an answer to that question. They shouldn't just go rogue and try to solve the problem themselves, when instead they should be either giving clear instructions as to how to answer those types of questions, or to contact HR or somebody else in the company who understands what to do. An additional issue with respect to supervisors, and I've seen this a lot as well, is that supervisors tell their employees to keep working, but to just report 40 hours no matter what. So what ends up happening when these things become litigation matters is an employee comes forward and says, I worked 50 hours a week, and the HR person in corporate says, no, we've got your timesheets. It shows that you were working 40 hours a week and you're not owed any overtime, or you worked a little bit of overtime and we paid it. And then the employee says, well, yeah, my timesheets say 40 hours per week because my manager told me not to report in the overtime, but he told me to work overtime. And oftentimes the manager's goals are to get production up and costs down. And depending on your business, a manager might even be incentivized in that way. And so there's an incentive for the manager to say, keep working, but we're not going to pay you for it. And that can create a lot of exposure for a company, because now however many people that manager supervises could have 10 hours worth a week of unpaid overtime, and going back a year, 2 years, 3 years. So that could really add up. So it's critical that while your managers and supervisors don't need to be FLSA experts, they need to make sure and make certain that their all time work by the employees that they're supervising is being captured. So I'd now like to move into a few specific examples, starting with waiting time. And this issue arises around employees who are, on call or work, or in some way on call. And as a general rule, true on-call time is unlikely to constitute work time. And within that construct, there's a term of art which refers to engaged to wait or waiting to be engaged. And things that would qualify as engaged to wait are compensable work time. And so the examples, and these come directly from the Department of Labor, is a secretary reading a book while waiting for dictation tapes to transcribe, or a firefighter sitting in the firehouse playing checkers while waiting for a call. These are engaged to wait and compensable work time, because in these cases the individual employees are restricted, and they cannot pursue their own ends, and they can't use the time for their own personal means. And by that I mean, they're in both these examples, the employees are required to be on site, required to be available, and can't just go to the movies, go to a ball game, go grab lunch. They're still working within the parameters of their employer, saying, hey, I need you here, I need you here. And when an employer says that, it's going to be compensable work time. In contrast, there's the waiting to be engaged category, which is not compensable work time. And the key distinction here is that the employee has freedom to be off-site. Now, a couple points here, and this is an example that I recently dealt with, is the IT help desk, and everyone who's running any level operation at this point is using computer systems and probably has people tapping into those computer systems over the weekend. And, I know that I do work over the weekend, and if I couldn't get into, our online file database, that would be problematic. Or if I couldn't get my emails to work, that would be a problem, and I would need to enlist our IT help desk over the weekend. And so, that's a good example of waiting to be engaged because, in our case, our IT people are free to do whatever they want over the weekend. They have, they can go to their kid's soccer game, they can go see a movie, they can go out to dinner. They're not restricted in their movement at all. The idea is that they're available, however, if a call comes in. So there's a distinction here, and I think the fine point on it is that being available does not equal compensable work time. So, that's a good distinction, is if someone's out of the office and they're required to be available, not compensable work time. If they're required to be in the office, compensable work time. Even if they can use that time in the office to play checkers or read a book. Of course, we'll get to it in a little bit, but there are meal breaks and there's other things that might make time in the office non-compensable, but for these purposes, I think that's sufficient. Another point I want to make on waiting to be engaged, there are some levels of restrictions that courts have approved. So, for example, I recently saw a case where a geographic restriction was in place, and the court still concluded that it was non-compensable time. So, in this case, the employer had a requirement that the on-call person not be more than 100 miles away from the office. And the court said, well, that's fine. You can still do pretty much anything you want. You just can't go out of town when you're on call. And that was found to be acceptable. Similarly, the Department of Labor has an opinion letter on restrictions of alcohol consumption while on call and has held that even that is okay. So if you said to your IT person who's on call over the weekend, you can't drink alcohol during this time because you could get a help desk call at any point, that would be acceptable. It wouldn't convert the time to compensable work time. Another common mistake is how employers treat meal breaks and rest breaks. In addressing the compensability of breaks, I think it makes sense to start with the proposition that the time is compensable until proven otherwise. And for meal breaks, that means the break should be at least 30 minutes, and during the entirety of that 30 minutes, the employee should be completely relieved from any and all work duties. So mistakes such as a 2-minute phone call in the middle of lunch could cause the entire meal break to become compensable. And in this regard, I've had cases too where, I've dealt with this issue, and it really is problematic because you think meal break, it's at least a half hour, and so we're not going to pay a half hour worth of time. Maybe this is a 40-hour-a-week employee. And if the meal breaks become compensable time when you thought they were uncompensable and the person works 5 days a week, now you've got 2.5 hours worth of time that you didn't pay anything for, that now you have to pay at the overtime rate. And so that's something that you have to be very conscious of. And so what I recommend is that you use the time recordation system to ensure that the breaks are sufficient and to guard against claims and litigation of mistakes. So if you make employees, non-exempt employees, punch out and punch back in for lunch, you've now created a record that the employee has had a part in creating as to the time of their lunch break. Now, the law allows for employers to calculate start time, stop time, and then to automatically deduct a half hour for lunch, as long as the employer has a process or a mechanism by which employees can fill out a form if they missed their lunch or had their lunch interrupted and get that corrected. But I just think there's too much risk associated with that, and I think it makes a lot more sense to have the employees punch out and punch back in around their lunch break. Another piece of advice that I would give with respect to meal breaks is that I think it's advisable to have non-exempt employees take lunch breaks away from their desk. Because in a lot of professions, an employee might take their lunch at their desk and get an email that they start responding to, or the phone might ring and they might pick up the phone. And now all of a sudden you've blown the lunch break and you owe that person for that time. The best way to avoid it is to manage away from it. With respect to rest breaks, these are generally considered to be compensable time, and the DOL literature and the case law around it reaches that conclusion because the rest breaks are considered to be for the benefit of the company. So by that I mean if your employee takes a 10-minute smoke break or a 5-minute break to walk around the office or to go outside and get some fresh air, the way the law looks at it is, well, yeah, the person's taking a break, but it's good for the company that the person take a short break and recharge. So, that's good for the company, therefore it's compensable work time as opposed to a non-compensable break. I'm not sure that taking a 10-minute smoke break is better or worse for the company than an employee taking a half hour for lunch. But in any event, that's the way the Department of Labor and the courts have analyzed these issues and where they've drawn the lines. Now, while there are more specific hours worked issues, the last category of tracking time issues I want to discuss today is travel time. And this is frankly probably one of the most complicated and multifaceted areas of tracking time. And that's because there are four main categories of travel, and they're subject to different applications of the law. So the first category is home to work travel. So that's like getting in your car and driving to the office, leaving the office, going home. That does not constitute hours worked. It's the general rule, and this is the simple general rule, is that commuting to and from your regular place of work is not compensable work time. Obviously, that's the case. We wouldn't, no one's paying for their employees to sit in traffic going to and from work. So that piece of this is pretty straightforward. The next category is one-day assignments in another city. And a good example of this, and this is something that I actually had a conversation with someone in my firm about this week, is, for example, my firm has multiple offices. So if someone who regularly works, a non-exempt employee who regularly works in the Baltimore office, has a project in our Philadelphia office and needs to take the train up to Philadelphia, is their time on that train compensable? And the answer to that is yes. And from a fundamental fairness standpoint, if someone typically has a 20-minute commute to their office in Baltimore, but now has a 20-minute commute to the train station and an hour and 20-minute train ride to Philadelphia, their day just got a lot longer. And, I think the law and fairness are aligned on this. That employee and that individual deserves to be paid for that additional time because the employer asked him or her to travel out of town and come back in the same day. The key point that I alluded to there is that the travel time that's compensable in this respect does not include ordinary commute time. So if it typically takes someone a half hour to get into the office and it takes them an hour and a half to go work in another city for a day, the compensable time is the hour and a half total travel time minus the half hour ordinary commute for a total of 1 hour, at least one direction. So there's a little bit of nuance to that. So, I think a practical solution is that, we won't pay you to get to the train station, but once you get to the train station, we'll pay you, for your train ride up, all the work that you do, your train ride home, and then when you leave the train station, that's when you're off the clock again. Now, the third category of travel time is travel that's all in a day's work. Now, at the beginning of this webinar, I said the workday begins with the principal activity, and this is an application of that rule. So if you come into the office and then travel to a job site, that travel time is likely to be compensable. There's some exception if you're running crews that prefer to ride as a passenger instead of meeting at the job site. And by that I mean, and this happens in a lot of, with respect to a lot of labor crews that have to go out onto different job sites. So for example, if everyone's required to get to the office or get to the yard or the facility at the beginning of the day, load up the truck with equipment, and then head out to a number of projects during the day, the travel time from the facility to the first job site is compensable for everybody on that truck because they started their workday by loading up the truck, figuring out what equipment they needed for that day, doing that sort of work. In contrast, if the employees were permitted to just go to the first job site and drive their own cars behind the company truck from site to site or to the one job site for the day, then that would fall, for those employees, would fall as home to work commute time and would not be compensable. Now, a wrinkle here is the scenario, and I think it's not that uncommon, where employees might not have their own vehicles, they might not have a desire to drive to all these different places, pay for parking if it's in a city, deal with the wear and tear on their vehicles, even though they're permitted to do that, and would prefer to just be a passenger in the company van on the way to the job site. And in that scenario, if the employee just happens to or decides that he or she wants to essentially carpool to the job site, and the carpool pickup location is the company's facility, their time as a passenger in the vehicle to and from the job site would not be compensable, provided that the employee is not doing any work at the facility before the company van leaves, is not doing any work while on the van, so not pulling out any blueprints or diagrams or talking about the strategy of the game plan for the day until they get on site. And then the same would be true for the commute home. So really the work is ending, the only time work is being done by that employee is on site. They're just riding as a passenger to and from out of their own, because it's more convenient for them and they're choosing that's the best way for them to get to the work site. If you have anything like that, I would strongly recommend putting an agreement in place to that effect. I've done that for a client in the past, and the idea is that when you're, as I described that scenario, there's some factual issues in there that could be disputed ultimately. For example, an employee could say, well, I was actually doing work before I left, and I didn't get paid for it, and all this travel time should be paid because I occasionally did a little bit of work beforehand. So with the client who had a similar issue, we put an agreement in place that said they were not allowed or permitted to do any work before or after, that they weren't allowed to do any work while in the van, and that if for any reason they did do any work, here's how you need to disclose it to the company so that we can pay you for it. Parenthetically, we can also discipline you for it, but we put a process and a procedure in place that guards against the prospective factual disputes that could come with something like this. Another wrinkle on that is the drivers have to get paid because they're driving the company van to the job site. And with respect to drivers, the distinction is more along the lines of whether they have to come to the company facility to pick up the company van in the morning, or whether they're allowed to drive the company van as their own personal vehicle, or at least take it home with them. That has an effect on whether the drive time to the first job site is compensable or not. And again, not to go into too much detail, but if a driver of a company vehicle just is allowed to take the vehicle home and just shows up at the first job site, then their drive time is not going to be compensable. However, if they have to come to the office first, if they have to pick up other coworkers who are carpooling, that could likely convert that time into compensable time. Now, the fourth category of travel time is travel away from home. And I think this is probably one of the most confusing because, frankly, the Department of Labor has rules that don't necessarily cover 100% of the factual possibilities. Travel away from home applies to overnight travel. And with respect to that, the Department of Labor does not consider it work if the employee is a passenger on a common carrier, and by that I mean an airplane, a train, or a bus, something like that, and the travel is outside regular working hours. So if a non-exempt employee's regular hours are from 9 to 5 Monday through Friday, out of town overnight travel that occurs between 9 and 5, even on a weekend, would be compensable time. If the travel occurs outside of the regular working hours of 9 to 5, the travel, whether it's a weekend or a weekday, the travel would not be compensable time. So there's a pretty large incentive for employers that are sending non-exempt employees away from home for overnight work to have them travel outside their regular working hours, because then it's not compensable. If you're sitting on an airplane at 7 o'clock at night, it's not compensable. If you're sitting on an airplane at 3 in the afternoon, even if it's on a Sunday, it is compensable. So that's something. Obviously there's some HR components to what you're doing when you're asking a non-exempt employee to spend time out of town, and that may affect how you want to pay for that. But you don't have to pay if it's outside the regular working hours, which leads to a question that I've had some experience with, which is, what are the regular working hours for someone who's a new employee? So imagine you get contracts all over the country, and when you get a contract, you hire people, specialists who happen to be non-exempt employees from all over the country to go to that site and do the work, whatever it is that they're a specialist in, go do that work there. They don't have regular working hours yet. And so, in the past, I've been able to successfully convince at least one court that in that scenario, there are no regular working hours. The employment hasn't even begun yet, and therefore the travel time to that, single site 3-month job is not compensable work time. So the last thing point I want to make with respect from travel away from home is that the Department of Labor carves out travel time when the non-exempt employee is a passenger on a common carrier. What it doesn't really address is, what about the time they spend driving their own car to the airport? Or what about the time they spend waiting in the airport? Or they get off the plane and they get in a cab, or they get a rental car. So there's some fringy issues there that I don't think are entirely clear. And I have some opinions about how to structure that and how to handle those situations. But I think those are other important questions that if you have people that are traveling out of town and spending the night in hotels, you want to get those addressed. And kind of as a side note to that, and this isn't really travel time per se, but if you have people traveling and working out of town, you're going to have a little bit more complexity with respect to what is work time, because maybe they go to a client site and they're there, and that's clearly work time. But then the manager wants them to go to a team dinner afterwards. Things of that nature. When does it actually work? So that's something that you're going to have to pay closer attention to as well if you've got non-exempt employees traveling for work. So with that, I will answer any questions. So if you have any questions and you haven't submitted them yet, feel free to do so. While you do that, I will let you know that Part 3 of the Wage and Hour Law webinar series will be next Wednesday at noon, and we will conclude our tour through the basics of wage and hour law by covering the proper method of calculating overtime pay. So, if you've enjoyed the first two or found them helpful, please and feel free to sign up for the third one. If you really like math, you should also sign up for the third one, because there's plenty of detail to cover with respect to the way in which the law operates to determine the overtime rates. So if you're a math person, you get a little bit of that as well. All right, so one question we have is, what about the practice of having exempt employees write down their hours? Is that problematic? If the person's properly classified as exempt and you're comfortable with that classification, I don't see a problem in having them track their hours as well. Obviously, you're not using it for anything. It's kind of to me, it's kind of like a safety measure in case you're wrong on your classification. You've got some hours recorded so that they can't say, hey, I worked 70 hours a week. If it's something you already do, I don't really see a problem with continuing it. If you're in a profession where you have exempt employees that are billable, you might already be tracking their time for other purposes. So I don't really see a problem with that. What can be problematic is where you're kind of wishy-washy on the classification. I don't think that's necessarily a great idea to do in those scenarios, because you're sending the wrong message to the employee. Okay, next question I have here is, when an exempt employee is expected to take phone calls after hours, is that considered compensable time? So that's a good point. I should have touched on it when we were talking about the on-call time, and I assume this probably should be non-exempt employee. If you've got a non-exempt employee like our IT person who takes phone calls or gets emails and has to call users like myself to help me through whatever my tech problem is, while they're not getting paid for the whole weekend that they're on call, when they're actually doing work, they are getting paid. So from the time, reading the email, giving me a call, doing whatever follow-up needs to be done, doing the actual work is, of course, compensable time. So if you have people that are working on call, while you don't need that, you're not going to just say, oh, you've got a 48-hour weekend, we'll pay you for all that. What you do need to do is to make sure that person on call tracks their time. So if they get a phone call at 8 o'clock at night and it takes them 20 minutes, then they've got you need a mechanism or a method for them to report that 20 minutes to you. All right, so this is a little more specific of a question, but I think it's probably worth sharing with everyone. Our employees do not punch time cards, but we track time by assuming they work their set schedule. If they work over, they submit a shift for that extra time, and if they miss time, they submit a time off request. Technically, they could be considered exempt, but we prefer to pay them overtime for any time they work over 40 hours. So, a couple good things to pull out of that. First, you can pay an exempt employee an overtime premium if you're so inclined to do so. But I would start from the proposition that if you're not checking off the boxes of what makes someone exempt, and that may or may not include the salary basis test, the other components, the things we covered last week, then they're not going to be exempt. And just because they could be, if you didn't pay them the salary basis and you were supposed to, they're not going to be exempt. So you would lose the benefit of the exemption if you're not hitting all the conditions. If you are hitting all the conditions of exempt status and you still want to pay an overtime premium, that's fine. You can pay any kind of bonus to an exempt employee. If you want to treat an exempt employee as non-exempt because you want to pay them by the hour or pay them a day rate and pay them some premiums, then that's fine too. But you should treat them like a non-exempt employee at that point, and make sure you're tracking time. And because what you don't want to have happen is someone say, I know I wasn't sure if I was exempt or non-exempt, but I worked this overtime and it's kind of rough. They didn't calculate it precisely, and there's some unpaid overtime out there that I think I'm entitled to, and that's what you want to avoid. And often what happens, I think, is that employers want to be generous with their employees, which is great. But when they're being generous, they're not thinking about what could happen if some employee was disgruntled or wanted to take advantage of this system. And as a result, eventually someone does take advantage of the system or the generosity, and like a lot of things in life, ruins the generosity of the employer for everyone else. So if you're going to be generous, that's great, that's fine. Just make sure you're doing it in a way that's safe and doesn't create any other issues for you. Another question is, should you refrain from using the term salary for non-exempt employees? So they're two different things. Salary is a method of paying someone, as is hourly, as is a day rate, as is a piece rate, which is pay for completion of a project. Those are all different mechanisms of paying someone. From an exempt and non-exempt standpoint, those terms have, they cross over, and how people are paid affects at times the exempt, non-exempt distinction, but it's not the same thing. An exempt, non-exempt means, whether or not you're eligible for or required to be paid overtime under the overtime laws. So, an exempt employee might be might also need to satisfy the salary basis test, and therefore might also be salaried, but they're exempt and salaried. Those terms are not interchangeable. Conversely, non-exempt and hourly aren't necessarily interchangeable either, because there are certain situations where they couldn't be used synonymously. So I would draw, of course I'm a lawyer, so I'm going to say it's important to be precise with language. But yeah, I would refer to hourly and salary as methods of pay, and exempt, non-exempt as to legal classifications as to whether or not the employee receives overtime premiums or not. All right, well, that appears to be all the questions that we have today. So this webinar has been recorded, and we'll post it on our website. I think you'll get an email with some details on that as well. And if you have any other questions regarding tracking time, you've got all my contact information, so feel free to reach out to me. And for those of you that are joining us next week, I will talk to you soon. Thanks for your time today. Take care.